Hi everyone. Okay, so we have had the hearing, and what I've decided the best thing to do because these posts are so detailed, I'm going to screen share them and go through them, and then just kind of give some commentary at the end. I think that's going to be the simplest thing to do. Okay, so again, thank you to Massel Russell Lee from Inner City Press for always providing these amazing court updates live. Okay, so let's begin. All right, and then Judge Lyman says, we are here for a pre-trial conference on the issues of experts and damages. Let's start with Miss Lively's experts and about social media. Miss Alexander, let me hear from defendants. So then, and it doesn't identify which lawyers. So I don't know. But Wayfarer lawyer, Miss Lively's expert is pure speculation. Whoever it is goes on to say Miss Lively's liquor brand was only around a day before the alleged retaliation campaign, so it is speculation. Her expert didn't speak with Deloitte. Betty B's projections were their own to raise funding. The expert's book speaks to this. So, obviously, just want to caveat as well. Matthew's not able to get word for word because he's, kind of typing as the hearing's in progression, and obviously there may be some spelling mistakes. Okay. The lawyer continues. For Wayfarer, Betty Buzz did not succeed for reasons that have nothing to do with the defendants. She has a track record of brands not succeeding. Her expert, Mr. Jeffrey Kinrick, didn't even consider or know about Lol Hatter. She may not have standing. So then the judge asks, isn't she claiming lost profits? And Wayfarer responds, people didn't like the companies because people didn't like Miss Lively, which is what I said, right? If you don't like a celebrity, the best way to demonstrate that contempt, to kind of protest almost, is to not watch anything they're in, not listen to any music, not buy their, the products that they endorse, basically, to boycott them. It goes without it. Like, it had to be, and I think that for me tells me, actually makes it quite clear for me that this is organic, because if they were trying to smear her, they just would have made her look like shit. But the thing is, right, people had to have not liked her for her branding to have suffered as well, because that is, physically people not buying her stuff. Okay. Just put my phone on silent because it's going to annoy me. Okay. Yeah. So, people did not like her, therefore her brands suffered, and that's because real people had to have boycotted buying them. If we were talking about just bots, putting crappy stories out about her, then bots are not going to translate into people going and buying hair products and alcohol products. Okay, Wayfarer continue. Miss Lively's expert, Richard Marks, says she is going to end up with, I think it's supposed to be end up with $132 million in 5 years. But she's only made just over 20 million on only 4 movies. Also, Richard Marks is of the opinion that there is a sequel to It Ends With Us, which we're now getting confirmation, which is hardly surprising. It's never gonna happen. Of course, they're not gonna work together again. But he has factored in that she would make money off the sequel. Wayfarer continue. Executives at Sony said that she was a terrorist. So this sequel is not going to happen. So that's not just Wayfarer's perspective either. That's Sony, who were also financing It Ends With Us, likely would have been co-financing, It Starts With Us as well. And that it sounds like what Wayfarer is saying is, hey, she was that bad. It's the position of both Wayfarer and Sony that we are not doing the sequel. Marks claims it would be a blockbuster, but he's no expert on that. He corroborated his findings with statements of her agent and manager. It's unrealistic. Shh, quiet, Mia. Wayfarer continue. Mr. Lively has only a sporadic work history, 4 movies in 8 years. Mr. Marks projects here working around the clock. Judge says, okay, you've got 3 minutes for a rebuttal, counsel for Lively. So it brings in Lively's attorneys now. She seeks economic and non-economic in reference to damages. Lively says her hair care line, Mr. Kinrick compared it to other comparable companies. Miss Lively already has a large following, 40 million followers. I think it was up to that. We can't predict the future, but there are real-world facts. Lively's lawyer comes and continues, the product made $7 million and exceeded the expectations. And then Lyman, Lyman was amazing. I'll get to that at the end, but then Lyman chimes in, I didn't read it that way. And then Lively says, there are always some discrepancies. It wasn't wildly off the mark. We allege retaliation started August 10th. A few days are key. Lively continues, this is a company Miss Lively invested herself into for 7 years, wiped out in days due to this conduct. And I find that a wild claim. How could you have been working on this company for 7 years? And then how could someone just come along and take, in a matter of a couple of days, destroy it? Literally destroy it, like from a, it's not going to bounce back position. How is that? Even if the court finds that Miss Lively cannot recover economic damages directly, reputational harm doesn't require a calculation. Lively continues, the jury has to have some basis to estimate the reputational harm. These are product lines that were based off her line, the beverage line. The harm is direct evidence of the value of her reputation. Lyman says, you've got 2 minutes. Roughly translated, get to the point. So Lively continues. Mr. Marks, he bases his opinion on a lengthy history of Miss Lively's earnings. Based on the success of It Ends With Us, we would have opened new opportunities. He has 50 years of industry experience. Lyman says, was it a blockbuster success? To which Lively has to reply, that's up to the jury. The expert is not required to say. He identified the maximum number of opportunities for an actress of her stature. The jury would decide there would be no sequel. There's evidence Mr. Baldoni wanted her to direct it. I mean, at the end of the day, I don't think that is a jury decision whether there's going to be a sequel or not, right? Baldoni may have said at some point when asked, are you going to be directing the sequel? He may have said, oh, I think Blake can do it, but I think Blake's ready. And he may have very, very, very early on in production, pre-production even, have hinted that, she should direct the sequel before all this bullshit happened. But the other thing I want to kind of comment on just here is they keep referring to, Miss Lively being an artist of her caliber, her stature. Can I just point out, right, that before Another Simple Favor, It Ends With Us movie was the highest grossing film of her entire career. It was the highest salary she'd ever commanded for one single film, okay? And she only got paid $1,750,000 dollars for that film. What I want to do now is just kind of just show you some comparisons. Just to kind of put into perspective, right, of some Hollywood stars and what they can earn per film. Her husband, on the set of the second, for the first Deadpool, he was paid around $20 million. For the second, it was around 22 million, and we know it's more for Deadpool and Wolverine. Now, he starred in Red Notice with Gal Gadot. He earned $27 million, okay, for that film. That was one of his highest paid roles. His co-star, female co-star Gal Gadot, made $20 million for that film, the same film. As Wonder Woman, she earned $10 million. I think that was for the sequel, though. She was paid an awful lot less for the original film, the first film she was in, which that was around $300,000. But for the sequel, she earned $10 million. And I think then I wanted to look at another female, and I picked Margot Robbie. These are just, there's no particular comparisons to Blake Lively, but they have arguably had far more success before the smash hit films. Margot Robbie was in Suicide Squad, for instance, amongst other things. But for Barbie, she earned $12.5 million. Now, they kind of, Blake Lively is $1.75 million, but it ends with us, is nothing, in contrast to all of that. So that's two female actresses they are A-list actresses. Something Lively claims to be herself. I don't think she is. And her husband as comparators. And Lively earns nothing compared to them. Literally nothing compared to them. So I feel like it's time to debunk this an actress of her stature crap, because I am sick of hearing it. But yeah, so I don't believe that it's for the jury to decide. I don't think it's a fact issue on whether there's going to be a sequel or not. They would just put Justin Baldoni on the stand and say, Mr. Baldoni, you own the rights to adapt the book into a movie. Yes, no. Not Wayfarer, Justin Baldoni. And he will say yes. And they'll be like, okay, so where are you at in terms of, is there going to be a sequel after all of this is sorted out? And all you need to do is say, nope. And he is the only one that can make that decision. And if he testifies that a sequel is not going to happen, at least not with Blake Lively, then that's that. That's the issue settled. Because it's not something Lively has any standing to dispute. She gets no say over whether there's going to be a sequel or not. And to be honest, it sounds like, this has actually confirmed for me that a lot of all of this, these allegations and, the lies and the lawsuit has all been about the sequel. Because we know what happened around October 2024, just a couple of months before they filed the CRD. Ryan Reynolds tried to buy the sequel from Justin Baldoni and was told no. We continued. Lively's lawyer. She has a 20-year track record. More opportunities should have been available to her. Mr. Marks' opinion should be admitted. And then Wayfarer says, the burden is on Miss Lively, and she had failed. She is seeking pie-in-the-sky damages. Which is fair. Okay, so that's over the damages. Sorry, the Daubert, one of the first Daubert arguments. Now we're moving on to the second one, which is Aaron Coletta. And then a different Wayfarer attorney comes in. Sorry, my kid is being noisy. A different Wayfarer attorney comes in. Her experts say they detected manipulation of social media. but the measurements are not probative of anything relevant in the case. I'll start with Coletta. Then Lyman asks, "You seek exclusion?" To which the attorney for Wayfarer says yes. Wayfarer then continued, "Miss Lively's expert relies on TikTok comment scores. It's not probative. Every single ratio or metric is not probative." Lyman says, "Let's focus on TikTok. Do you dispute he has offered enough evidence?" And Wayfarer says yes. So the judge then says, he says there were an unusual order of likes on the comments rather than the post. And Wayfarer respond, "Usual does not mean inauthentic," which is a very fair statement to make. "Users sometimes react unusually to celebrity feuds. He focused on certain hashtags with the top comment score elevated." And then Wayfarer continue. Judge Engelmeyer of this court in 2020 said that the courtroom is not the place for innovation. For example, on measuring social media manipulation, the Premier showed the rift. With Mr. Baldoni excluded, she launched a hair care brand. They continue, "Ms. Lively was criticised for, during the launch of a film about domestic violence, promoting her alcohol brand and her husband's gin brand," because they did that too. There was his superhero film. Professor Maislin ignores all of this. It is not a discontinuity design. And then Wayfarer continue. Professor Maislin's use of artificial intelligence incorrectly classified many posts. The model misunderstood her instructions. It picked up posts that were negative about anyone, not just Ms. Lively. She used GPT-4. It has been criticized. Wayfarer continues. She certainly did not look through 1.1 million posts. Yeah, and that's fair. She did not sit there and go through 1.1 million posts. And they're saying, look, she used AI to analyze, and the AI she used is unreliable. So her report relies on her AI. It should be excluded. She aggregates allegedly actionable and non-actionable posts. Lyman then says 1 minute from the 12-minute mark, reminding him of the time. And then he says, "I'll hear from your adversary." So Lively's attorney jumps in then and says, "Dr. Coletta, my friend objects to the case law. Your Honor has addressed this in USA against Ray." Lively continues, "Nefarious actors engage in algorithmic manipulation." Lyman asks, "Are there any more studies?" And Lively says, "Just the 3. We have a wealth of material from the defendants that Mr. Wallace was engaged in manipulating the comment sections." Lively continues, "Initially 1.7% of the audience engaged with the anti-Blake Lively comments. Then it went up to 22%. It is indicative of," and Lyman says, "indicative?" Lively says, "He does not try to show causation." To which Lyman challenges a little bit and says, "Well, maybe mass audiences developed a negative view of Miss Lively." Yes, they did exactly that. Lively's lawyer says, "Why only in August of 2024? There was a video, then a comment that her husband wrote whole scenes. It got more engagement. There is evidence of Jed Wallace on Ryan Reynolds." I don't even know why we need evidence of anything to do with Ryan Reynolds, because he is not in this lawsuit. Lively's attorney says, "Dr. Coletta has an opinion about YouTube comments through the YouTube API about the little bump. He tracked bully-related posts. There were 14 before August 14th, then 700 after. This is a temporal fingerprint useful to the jury." Lively continues, "Professor Maislin says the use of AI is accepted. She had a trained model that was classifying the post. The errors impacted less than 1%. She conceded this and called it acceptable. As to Alexander, there is a new declaration on April 24th. Lively continues, Miss Lively would be prejudiced if Professor Alexander is allowed to testify without us being able to depose and test her, since her change. She admits it was backward. Her corrected data. And then Lyman cuts him off and says, you're out of time, finish your sentence. And they do, should be excluded. Then Wayfarer come back in and make a fantastic point, which a lot of people overlooked. And that is, Lively's counsel claims these negative themes were absent before April 2024. Miss Lively was called a bully for bullying Princess Catherine. And obviously, that's true. She put up that ridiculous post on X, taking the piss out of Kate Middleton. And that was at a time where it was known that she was very, very poorly. But we knew she'd had surgery, even major surgery. But we did not know that she had cancer. And I think she came out a day or two after Lively's ridiculous post mocking her. And as a result, Lively had to do she had to delete a post. She did an apology post, but she earned a reputation which a lot of people haven't forgotten, especially us Brits, that she bullied a woman who was sick. And regardless of the fact of whether anyone knew that Catherine had cancer at the time, we certainly knew, the world knew, that she had had major surgery. That should have been enough. Professor Maitland admitted TikTok data is not reliable. And then Lyman asks, and on Alexander? Wayfarer then state, it was only an error in the data file. It was not covered in the deposition, so we corrected it. Lyman says, okay, now on the admissibility of evidence of the Wayfarer party's lawyer suit as retaliation. So now we're talking about Friedman. Wayfarer say the complaint was dismissed, but not as frivolous. The court said there was powerful evidence that Miss Lively provided her California complaint to the New York Times before she filed it. The dismissal is based on an unpublished California case. Wayfarer continues, I want to touch on the Rule 11 issue, and Lyman does say, I don't think you need to spend much time on that. So Wayfarer say, Mr. Friedman's comments were made after the filing of Miss Lively's claim. They are entitled to the same protection. Lively then responds, Miss Lively was privileged not only to file her complaint, but to also speak about it. And Lyman says there is evidence on both sides. Lively then says, California law prohibits them from filing a defamation suit about a CRD complaint. And I just want to point out, they didn't file the suit about the CRD complaint. They filed it about the New York Times article. And that is quite clear, given that in the first court filing, the first action that Wayfarer took following the CRD and the New York Times article was to sue the New York Times. They did not sue Lively. They sued the New York Times. It is very, very clear that they were suing because of the article. Lyman says, if I accepted your position, would have a right to argue at trial that Miss Lively is a liar, that she propagated something knowing it was false. Lively says, we'd be fine with that, but the court has already ruled on some claims. Lyman says, I ruled on technical grounds. They still have an appeal, and I think I'm glad. There was he cuts off Wayfarer, and you can see he's already bending to Lively at these hearings, but he was very much straight down the middle. If anything, he was Wayfarer leaning today. So it was nice to see that. Not trying to make much happen for Wayfarer, but he was like being quite fair and pointing out the flaws in Lively's arguments, and backing up Wayfarer. So that was entirely refreshing to see. Yeah, so Lyman says, I ruled on technical grounds. They still have an appeal. Lively's lawyer says, that's why this issue is teed up for the court on a motion. It's for the court to decide if Miss Lively's CRD complaint and her public comments were made without malice. Shh. Lively's lawyer then says, our 47.1 motion says they used their lawsuit to cause reputational damages. Lyman says, would that be subject to a retaliation lawsuit? Then Lively cites the Bill Johnson case of the Supreme Court, which says there's an impact on an individual's reputation. And Lyman then asks, haven't you talked yourself into Mr. Friedman's statements being excludable? Lively's lawyer then says, Miss Humphrey's report goes to this. Lyman says, you're changing your course, it seems to me. Let me hear from your adversary. So then Wayfarer come back in and say, this was fair game. Of course, any defendant can defend themselves in a counterclaim. I am confused by Mr. Gottlieb's statements. He seems to argue that a defendant cannot defend their case under Rule 47, under 47.1, but Rule 11 has a different standard. Then Lyman wants to hear on bifurcation. So Lively says, Mr. Saueritz spoke of spending $100 million on this. Even if Miss Lively was not aware of other people's experience, it still goes to reasonableness. There's the Mendoza case, and then Lyman cuts them off and says, I'm aware of it. Wayfarer then responds and say, Mr. Saueritz is no longer a defendant in the case. His personal wealth is now irrelevant. If plaintiff would like to argue that resources were spent in defending, would Mr. Reynolds' wealth be relevant? Punitive damages should be bifurcated, and I do agree. So then they had a break, came back. Then Lyman says, I'm thinking of next week having a hearing with 3 of the expert witnesses. 1 hour of cross and 1 hour of direct on each of them. Let me know their availability. And then someone, it doesn't say who, but someone asks, is that Maislin, Carlotta, and Alexander? And Lyman says yes. So next week there's going to be a hearing, like a bit of an examination and cross on those 3 expert witnesses. Lively's lawyer then says, we'd like to seal the birth video. And I've got some stuff to say about this. So Lively, after all that fuss over the birth video of Jamie and Natasha Heath's birth video that she claimed was pornography, she claimed Natasha Heath was naked with her legs spread far apart, now wants to seal the video. Wayfarer said, we don't think there's a need to seal. And the only reason for me that's striking, there may be, other things like, but one that's coming to the top of my mind is that she doesn't want us to see it. Because it, like the slow dance video, like the Claire Ayub recording, like the birth scene video, the birth scene footage from the film, when we see it, we will all sit there scratching our heads going, what the fuck was her problem? There's nothing here. So that's why I think she wants to seal it. But Wayfarer are like, nah, we're good. Release it. And I got to say, I'd love to see it. Not because I'm expecting there to be anything, anything. I'm not expecting any nudity or anything like that. But I want to see what Lively saw. And then don't forget, I did my video going through Anne Fromholtz's report. She's the kind of intimacy workplace investigation expert for Wayfarer. And she noted that she saw the video. And Lively, by her own testimony, stopped Jamie Heath from showing her it almost immediately within the first few seconds. And Anne Fromholtz testified in her report that if that's the case, there was definitely nothing that would have been, offensive or would have crossed the line. There was no nudity at all. So, Yeah, I'm quite keen to see it because I do expect, like everything else, it will turn out to be a great big nothing burger. Um, so Lyman says, so it's resolved. Any third parties have privacy interests. Other than what Mr. Wallace has said, meet and confer. So it sounds like they're going to meet and confer over the birth scene. But I mean, ultimately, you know, if Wayfarer are happy, if Natasha Heath is happy for it to be unsealed, it is more likely than not to be unsealed, because sealing should be reserved for kind of exceptional circumstances anyway. And I know Lyman is you can say what you want about him, right? But in fairness, he's a stickler for, continuing to assert the First Amendment rights, the public right of access, and making sure that documents that don't need to be sealed get unsealed as soon as possible. Then they go on to how much time each side will need for the trial, and Lively's lawyer says 15 trial days. Then Lyman asks Wayfarer, who say, well, we ask for equal time, but we are trying to get a stipulation that might shorten it. So that's a month of trial. That could be, sort of between 4 to 6 weeks of a trial. No, it will be 6 weeks, won't it? Trial days, because that's the weekends as well. So that will be a 6-week trial, Monday to Friday, for 15 days each, which is it's a long trial. Lyman then says that he's working hard on the motions in limine. He'll address other issues at the end of the Daubert hearing. Anything more now? And then it says counsel, but I think this might be Lively's counsel. Says we'd like to have prosecutive jurors answer on hardship even before they come in. Judge Subramanian did it in Coombs, which is the Diddy case. And then Lyman responds, but not in the Live Nation trial. Lively's attorney then responds, some prospective jurors may be passive participants in the conduct alleged here. If they answer in front of others, it could infect the jury. Lyman then says, it's hard for me to imagine anyone today other than a federal judge not using social media. Wayfarer then say, well, why are we only hearing this now? I'm guessing that's in response to the request about the jury and not the fact that Lyman doesn't use social media. Because I got to say, the way it was written, I was like, what? Did Wayfarer not know that Lyman is not on social media? But then it's just the way that threads go. But I had to go back and read it all together. I was like, oh, okay. Yeah, Wayfarer's a lawyer. Why are we only hearing this now? These questions are too detailed. We can meet and confer. Lyman says, I'm not unaware that this case has generated some interest. I'd rather question the prospective jurors in person. Okay, it has been a long day. And then the case was adjourned. So we don't know much here at all. We've not had any decisions. And there is going to be another hearing next week on the those 3 experts. Mia. The one thing I'm really curious about is Lively is going to sit there, right? And her lawyers, like this, right? Lively's attorney, initially 1.7% of the audience engaged with the anti-Blake Lively comments. Then it went up to 22% is indicative of, right? And Lyman does cut them off, right? But if there's a 1.7% of audience engagement, which then shoots up to 22%, that just tells me something went viral. It was a very similar reaction to the Coldplay concert where that man and his who was cheating with his assistant were kind of on like a kiss cam type thing, and it turned out the guy was married and with his side piece, you know. um, and that just went nuts. Like it went so viral so quickly, and I don't think anything different has happened with Lively at all. There was, a series of things that people did not like. People really, really had a bad backlash for the whole Princess Catherine post that she put up. And then, on top of that, you had the marketing, you had location share, you had, I'm going to sell, my products. And it's all about, be floral, grab your friends, and go and see a film about domestic violence, whilst pretending that the film wasn't about domestic violence, which was not how the book was marketed. Um, Fans of the book, and there was a huge fan base of it, were very much of the opinion that it was a book. The book was about domestic violence, and they expected the same from the film. So when Lively's running around talking about her friend Taylor Swift and look at my jewelry, look at my fashion, look at my clothes, look at my husband's socks, look at my husband's gin, look at my husband's film, look at my alcoholic beverages, my non-alcoholic beverages, my summer drinks basically. Oh, and my hair care range. And the marketing involves baking cookies and doing people's hair and doing flower arrangements. I mean, the flower arrangements I can kind of get past that because of the florist theme. Everything else makes no fucking sense. The flowery jeans, the junket with Brandon Sklenar and Ryan Reynolds and Hugh Jackman and Ryan Reynolds' mother. None of it it does not make sense. And that pissed people off. So, and my theory has always been people didn't really know who she was because she is not an A-list. She wants to be an A-list. She is not. And they probably Googled her and went, fuck. But then, an even bigger spike happened in December after Friedman went on Megyn Kelly. Why? The New York Times has now published the article. Eyes are on what's going on here. Because it is like initially, it is the first case of this kind since Depp Heard. And, Lively had a lot of her celebrity friends coming out and just making very public comments. So, and Friedman is not just, an average attorney. He's famous in his own right. He has a well-known reputation. He's highly sought after. He's very, very good at what he does. And people, love him and follow him as well. So when he does an interview on like a show like the Megyn Kelly show or TMZ, people are going to tune in. And when he's sitting there going, this is a lie, this is a lie. She put him in the basement. Did you know he was in the basement? Nice pool. They made fun of Justin Baldoni on a global stage by creating the Nice Pool character to mock him. And we all sat there listening to this. And it's the first time we're hearing really that side of the story. So, yeah, I think people were just kind of, their jaws hit the floor. And we're like, what the hell? And people tuned in. And then they were like looking up this person who put a man, her director, the studio who produced her film in the fucking basement, because that is beyond cruel. That is incredibly cruel. I think this time people just got sick of it, and the reason it gained so much traction as well is because of the, again, it's another Hollywood case where a bratty actress has levied false accusations against a really nice man, a kind man. And like the difference here is with Johnny Depp, right? He was an incredibly nice man. He did very charitable, very, kind, but he had his faults. Like there was a limit to how nice he was, and I think he's incredibly nice. And he did not deserve the false allegations. But Justin Baldoni, that's a whole different kettle of fish, because you know when you try and find something awful, I mean really awful in his background, there's nothing. He's about as pure as it gets, and you cannot believe what you're hearing. And then the evidence comes out then and confirms that you were right not to believe what you were being told. And not only that, she smeared all these really lovely, lovely, lovely charitable men. And it's not even the men involved in the lawsuit. It's not just Jamie Heath, Steve Sauerets, Justin Baldoni, and Jed Wallace, right? And Jed Wallace is a colourful character. I like him, and I think he was treated incredibly unfairly in this lawsuit. But he has been involved in other lawsuits where, he's not innocent. However, she also took down Adam Monshine. Even though she didn't sue him, she decimated his reputation by not acknowledging that he was an actor, by suggesting that he only took the part because her legs were going to be in stirrups, so he'd be close to her fanny. Like really, really terrible things to insinuate about an actor. Okay, so that's it for me. That's where we are. I will keep posted on anything else that comes out of this. I still have some more videos to upload as well from this, which I recorded earlier. So there's a few more things to come from me today.